Welcome to the Life and Transitions Experts podcast, here where I'm helping families and people navigate the probate process, or possibly you're dealing with other transitions in your life, such as needing to deal with property and stuff in a move. Perhaps there's someone in your family that needs to move to a senior community. As Life and Transitions Experts, we're here helping folks through those biggest transitions, providing some type of valuable, so hopefully viable and valuable solution to some of the challenges that you may face. So today we're actually going to look at probate in North Carolina. I call myself the Durham County probate specialist, probate expert. That doesn't mean that I know everything about probate. I am not an attorney or a financial advisor. I'm just sharing my opinions, but I am committed to the process. And that's why I call myself the expert, because I'm committed to the learning process, committed to learning as much as I can about probate as I'm helping families navigate it, as I'm helping families deal with properties and whether real or personal that's in the estates. As I gain this information, I share it with you, and hopefully, again, you'll find it valuable and help you hopefully avoid probate in the future, as well as deal with the possible probate that you're working on now. So today we're going to look at small estates. Not every probate or not every estate in North Carolina has to go through the large estate process. And we're going to look at what it means to when there's a property that's, or not property, but an estate is relatively small. So let me share my screen. All right. If there is enough money in the state, do you have to go through probate in North Carolina? And technically, the answer is yes. That it is a probate process. It's just a different type of probate, and the statutes or the requirements that have to be met look different than a large estate. And we're going to get into it. And just a reminder, or just let folks know, probate is the process of settling the affairs of someone who's passed away. If someone passes away with debt or assets in their name, there has to be a legal way to put those into the proper places, so it's zeroed and all things are addressed. This is the general overview process of the probate process. Whether you're an executor, means you're executing the last will and testaments of the person who passed away, or you're an administrator, meaning there was no valid will left, so now you're administrating the estate. These are the steps in the process. You're opening probate, notifying any creditors, distributing any assets, that's taking inventory and accounting, selling the debts, and closing the estate. The one, two, three, four, five, third, fourth, and fifth button are well, you definitely handle the debt first, and then handle the disbursement, and then the accounting to make sure it zeroes out. So maybe I need to change that order because I don't want to lead anybody astray, but those sort of happen almost at the same time. So small estate collection by affidavit. What is this? When estates meet certain criteria, it does not require going through the large administration or execution of the process. And here are some of the criteria. This is taken, copied, and pasted straight from the estate's procedures manual. If the decedent died on or before September 30th, 2009, and the value of the personal property or the liens or the encumbrances does not exceed $10,000 or $20,000 if the surviving spouse is the collector or sole heir. I mean, they're the sole heir of it. Then you don't. Then you can do a small estate collection. All right. So if it's lower than $10,000 or $20,000, if there's a surviving spouse, regardless of the value of any real property, because let's go. So you don't have to necessarily count the house at all, because one, that could pass through testate law for North Carolina, or well, it passes through based on intestate law through North Carolina if there's not a will left behind, and through succession law in North Carolina if there it's dictated by the will if there is left behind. So it doesn't matter the value of the real property is what I'm stating. Another criteria is and if the person passed away after October 1st, 2009, and the value does not exceed $20,000 or $30,000 if there's a surviving spouse, then you can do probate. So it went up in October 1st, 2009. Now the criteria, the baseline is $20,000. And if it's after January 1st, 2012, and the value of the person does not exceed $20,000, then you're able to do it, or 30,000 for the surviving spouse. Now I want to check on that because those look like 20,000 and 20,000. I wonder why they're similar saying. So I'm gonna have to do more research on there because I need one more thing I get to understand a little deeper. And yeah, so I want to make sure that that's understood. What's the difference between the on or before or after does not exceed 20,000. Oh, and spousal allowance is counted now. Okay, the spousal allowance is counted in there. Okay, interesting. Okay, I'm gonna dig a little deeper in there. Maybe I'll do a podcast on that, or a story or a podcast on that tomorrow or in the near future. But yes, now this one has a spousal. Okay, all right, interesting. All right, so the steps are pretty simple. You'll distribute the assets and address any claims. So the assets are paid off, or the claims are paid off in this order: the payment of the surviving spouse, any children, if they're apply for a year's allowance, and then you pay the debts and the claims based on the order of priority. Go back and check my old YouTube channel and videos if you want to see or article on the order of priority, or Google it in or reach out to me and I can definitely get that to you. And so now you've sent the allowances to the surviving spouse or children, if there's any. You've paid off all debts, and hopefully you've negotiated those debts to maybe hopefully zero some out or get them reduced. But you paid off all debts in order of priority. Now you can start distributing the remaining assets to personal property to folks who are entitled by the will, or if there isn't a will, based on intestate succession on law. All right. And after that, you're closing it. You'll send the affidavit. I think it's form 203, 502. I have the forms here in the show notes, so you can use those. And you go to my website. I have all the forms that you use for North Carolina probate in a convenient spot. So you're done right there. If you do need more support or help, I do try to address this in the most holistic way possible. All non-legal issues, I do stay in my lane, but all non-legal issues really we help you get through. If there are legal issues, and one of the best things, one of my favorite things to do is recommend you to the proper attorney that can help meet your needs. And there's tons of things outside of the attorney's office that we can help you with as well. Check us out every Wednesday. We're here really every day, but every Wednesday at 12 o'clock, I go over the probate process. It's just a deeper review of the process. And if you have any questions, of course, reach out. If you want to come there on Wednesday, we'd love to see you, and you can share your questions or your thoughts there. And other than that, this is Courtney Rollins. As I always say here, life and transition experts, let your light shine. See if they let me get off of here. Cheers.